May Lordship, the ex parte order as continued the 6, it is at page 28, dated 20th of May 2020, by which my agreement has been rescinded under and my lord, all the security money and earnest money deposit has been forfeited. So certain dates are relevant, Lordships. Agreement executed on 40/10/2017. 1/14/10/2017.
14/1/2017.
No, so 14th October, 14/10/2000. As per the agreement, the completion date was 13/10/2018.
13/10/2018.
Lordships. Lordships, immediately it was noticed that the main bridge was damaged. So therefore, a proposal for extension of time was forwarded on 22/6/2018.
What was awarded?
A proposal for extension of time for completion of the work.
On what date?
It was on 22/6/2018, annexure 2. Then, my lords, the chief engineer confirmed the proposal and recommended it to the headquarters on 21/5/2019. 21/5/2019.
It was extended up to what date?
No, it was never extended.
But it was confirmed after last date.
Yes, yes. Thereafter, this is what was, and thereafter, the executive engineer, without realizing that proposal for extension of time is pending and the time limit has already expired, on 7/9/2019 directs the petitioner to complete the work without there being any extension of time.
On 7/9/2020, what he has
7/9/2019.
What he has done?
He asked the petitioner to complete the work, notwithstanding the fact that there was no extension of time, it was pending. Again, my lords, the same executive engineer on 16/1/2020 directs the petitioner to complete the work within 1 week.
2020.
Lordships, yes. And now on 25/2020, he resigns the agreement. All has been done after the agreement was closed, matlab agreement had lapsed and the proposal for extension of time was pending. Now it is very relevant to notice that on 20th May 2020, the executive engineer rescinds the agreement, but the engineer in chief, who is the head of the department, he on 19/6/2020, mean 1 month thereafter, writes letter to the executive engineer on some issues with regard to clarification on the proposal for extension of time. He has some doubts, so he writes that please clarify. And the executive engineer again clarifies it after a lapse of about 8 months on 6/2021. So 2021, annexure 8.
2021.
Lordships, yes. And thereafter, on 18/3/2021, the same executive engineer, without any notice, again decides to get the remaining work completed at my risk and cost.
Your work?
The work he wants to complete it at my risk and cost. He wants to get it completed by another contractor at my cost. So, Lordship, admittedly, the work could not be completed for the reasons beyond my control. There was a proposal for extension of time pending, which was signed by the same executive engineer. And after the agreement had expired, he rescinds the agreement, which has a serious penal consequences. And the other ground is that no notice to show cause contemplating such an action as to why this action be not taken was ever issued to me. Yes, one letter was issued, but it can't be treated to be a show cause notice. It was mere a direction.
Before 20th May 2020 action,
Lordships, yes.
you have not been given notice.
No, I was not given notice. The letter which they rely, it was only a direction to complete the work. So direction is a direction. It is not
But direction letter?
Yes, it is at annexure, my lords, 5, 16/1/2020. It is, my lords will find.
But last 2 lines of this letter,
Lords.
it put you on notice that your agreement would be rescinded if you do not.
Yes, this is what I was submitting for my lord's kind consideration, that it did not ask as to why I should not be rescinded. It says that if you don't complete, we will be rescinding it.
Then what steps you have taken?
No, Lordship.
On receipt of 16/1/2020.
Lordships, yes. Thereafter, Lords, we were continuously, Lords, in the communication, and after that, Lords, I have also submitted various.
What steps you have taken, sir?
Lords, that communication, Lords, I have not brought on record, Lords.
You have stepped over the matter with reference to.
No, I may be permitted to bring on record, Lords, because the petitioner, I inquired this, but he is not in a position, Lords, to bring on record because it was a COVID period, Lords. So, Lords, I may be permitted to bring on record. I will verify it, Lords. And thereafter, because it transpires that the petitioner was pursuing, because only then, Lords, the engineer in chief had written a letter, Lords, post rescission of my agreement.
You have stepped over the matter after 16/1/2020.
Well, prior to COVID period.
So 16/1/2020.
My lord, he was
Last 2020.
required to complete the work on 13th of October 2018 itself.
13th October
My
2018.
lords.
Yes, so thereafter, Lords, admittedly, he himself admits that the main bridge was disrupted. Yes, Lords, this is the proposal for extension of time. Lords, it may be passed on, Lords, I will bring on record my communication.
We have heard you.
My lord, previous judicial orders may kindly be perused, my lords. About 6 months back, Lord, he has taken time to file a reply to my counter affidavit. As of now, Lord, I haven't received any kind of reply.
Lords,
And Lord, would you
the
please-
petitioner has broken his leg, my lords. I just talked to him, my lord. That is why, my lord,
Huh?
because I'm not sure. The petitioner has broken his legs, my lords,
Yeah.
and he's bedridden.
On what date?
Just 2 months back, my lords.
What? What is the date?
My lords, he communicated that
He is not discharging the duty. He is only supervising.
the contractor lordships. Lords, no, not any. But only to be passed on, Lords, I will just bring on record.
Sorry.
Lordship, in that case, Lords, this proposal, Lords, that Lords, to that extent, Lords, but there, Lords, what happened there after post rescission of my agreement, this is 16/1/2020, Lords, if my Lords is pleased to see the action, Lords. Now, after my agreement was rescinded on 25/2020, annexure 6,
13/10/2018. 16/1/2020. You did not complete the work.
yes, Lordship, and Lords,
It is more than 1 year.
yes, Lord, it is more than even today it can't be completed because Lords, the main connecting bridge was damaged. They themselves admit, and that is why they recommend for Lords extension of time. The chief engineer also accepts that yes, the bridge was broken, and therefore the work could. If just Lords is pleased to see, Lords, annexure 3, page 24. It is the letter of the chief engineer to the engineer in chief that ye vridhi.
Such a defect was noticed in the year 2018 itself.
Lordship, yes.
And you have sought time.
I have not sought time. It was for the department, the
Sought time.
jurisdictional officers. I can't seek time. The jurisdictional officers, they send a proposal.
That is the case. On what date you have completed the project?
Vinay, as of
What date you have completed the project?
This is what I am saying. The project could not be completed because the main bridge was. And just see, Lords, this is what I am saying. It is very.
my lord, the question arises.
Just my lord,
It is not a 1 or 2 months. It is more than 1 year.
Lords, I am just saying that it is more than 1 year, Lords. If my lord, and still today, the bridge is disrupted. This is what. If my Lords is pleased to see the reason is
We are
beyond.
not concerned with that, whether it is still work is going on or they have undertaken some repair work or nothing.
Yes,
We are
Lords.
not concerned. What? Yes. Yes, take up.
My Lords, if my Lords is pleased to see my this submission, my Lords, just my Lords, because annexure 7, page 29, if my Lords is pleased to see. This is very relevant.
Shows your intention to complete the work
Yes.
from 22/6/2018 onwards.
Yes, Lord.
61/2020. What action you have taken?
Keep that. I'm just. My Lords, my annexure 2, page 23.
What is the date?
This is my Lords 22/6/2018.
22/6/2018.
Lordship, yes.
80.
Yes, sir.
No, correct. From that day, 16/1 to.
Lordship, my humble submission is the moment my proposal for extension of time is forwarded, unless my extension of time is Lords given to me.
Was there any prohibition?
Yes.
Not to execute. Show us the document. Where is that prohibition?
Lordship, this is by operation of law. The moment the time limit for completion of the agreement lapses, the agreement is dead. So therefore, there is a provision for extension of time that if for the reasons
Sorry.
beyond my control. Lordship, yes. If my Lords is seized to the proposal, my Lords, annexure 2, annexure 3, my Lords. This is
You still argue we are going to impose cost. We have heard you.
At least, my lords, to
Portion of at least.
no, my lords, the second submission is, so far as the signing order is concerned, my lords, I could not persuade, my lords. But so far as that part is concerned, by which they are trying to get the remaining work done at my risk and cost, that is beyond show cause, that is without a show cause notice.
All right, he shows what action they have taken. At
Yes.
have they deducted?
Yes, everything forfeited and they are deducting it. This is not my
Where
lord.
is the order?
Yes, this is-
Show that the remaining work was executed by third party and the amount is this.
Ji, ji.
This has been deducted from your
Ji, Ji, lords. This is the order. Annexure 9, page 36. Annexure 9, page 31.
Annexure 9.
Page 31. And what they have done, they have asked me to deposit, and at the same time, they have forfeited my security deposit also. They are sitting tied over the proposal for extension of time. They are
So
not.
far as remaining work is concerned, we will give you liberty. You go and approach the authority.
For me, not the.
Past, which is required to be adjusted from your account, you go and approach them.
Plus, to that extent, my lords, I may be permitted to invoke the arbitration clause also. Because my lord, then they have already.
All right, then we will impose cost. You can't have one leg in High Court, one leg in arbitration.
But no useful purpose would be served because they have already taken a decision. If my lords is pleased to quash this decision, my lords, so far as the risk and cost part, I am deciding, I am not arguing.
As risk and cost is concerned, we will give you liberty to approach them with the material information.
Okay.
Instant petitioner has prayed for the following relief. The petitioner that contractor has entered into agreement on 14/2017 insofar as the execution of work. Agreement was invoked till 13/10/2018. In other words, petitioner has to undertake a completion of a work before 13/10/2018. Admittedly, we have not completed the work before 13/10/2018. So in the meanwhile,
Lordship, I am very sorry, Lordship. I am very sorry, I am just interrupting. And extra I page.
main bridge, like certain damages to the sub. In the meanwhile, there was a proposal for extension of time on 22/2018 for completion of the assigned work. In this regard, there was a protracted correspondence among the chief engineer and executive engineer. It was continued up to 18/3/2021. In the meanwhile, impugn action has been taken like rescinding and withholding of EMD, security deposit, not withholding, forfeiting. Thus, the petitioner presented his petition styling the impugn action dated 20. By Annexure A6 with reference to agreement number 09/2017 dated 14/10/2017. When counsel for the petitioner submitted that there were certain correspondence was invoked for the purpose of extension of time from 22/6/2018 among the chief engineer and executive engineer to start. During pendency of correspondence among chief engineer and executive engineer on 20th May 2020, impugn action has been taken. To start. In the absence of finality, insofar as extension of time to complete the work, the impugn action is arbitrary and illegal. Further submitted that on 19/3/2021, the executive engineer proceeded to provide remaining work to a third party at a risk and cost of the petitioner. For control and counsel for the respondent submitted that there is no eligibility in the impugned action dated May 2020. The petitioner has failed to complete the work within the time limit stipulated on 13th as of 13th. Moreover, it is submitted that certain damages was stated to have been caused to the main bridge, which was noticed by the official respondent. In the light of these facts and circumstances, no interference is called for insofar as the impugned action is concerned.
And in fact, several reminders were also sent by the concerned authorities to complete the work. And further,
Also submitted that number of reminders were issued to the petitioner to execute the work with reference to agreement dated 14/10/2017. Further on counsel for the respective parties. Undisputed facts are that petitioner contractor has executed agreement on 14/10/2017 to complete the assigned work on or before 13/10/2018. It was not completed, and so also there were certain alleged damages in the main bridge, which was taken note of by the concerned official. Merely correspondence relating to extension of time between the chief engineer and executive engineer, the petitioner cannot take shelter for the purpose of extension of time and execution of the remaining work beyond 13/10/2018. The petitioner has not apprised this court as to what action he has taken insofar as execution of remaining work during the intermediate period from 13/10/2018 to 16/1/2020, the date on which the executive engineer had requested the petitioner to complete the work within a period of 1 week. In the light of these facts and circumstances, it is evident that there are certain lapses on the part of the petitioner in not executing the work assigned within the time limit, and so also work seems to be substandard in view of the fact that the main bridge was stated to have been damaged. Hence, no interference is warranted insofar as impugned action dated 20th May 2020. Next paragraph. Insofar as communication of the executive engineer dated 18/3/2021 in respect of assigning the remaining work to a third party, and the petitioner has to bear the risk and cost is concerned, The petitioner has not been heard in the matter. Therefore, the concerned authority is hereby directed to issue a detailed show cause notice to the petitioner, and on receipt of petitioner's explanation, proceed in accordance with law in passing a detailed speaking order and communicate the same to the petitioner. With the above observation, writ petition stands disposed of.
Because there are two things, my
In
lord.
fact, that is a consequential order of.
It may not permit one statement, my lords. My lords, I was not able, my lords, there is a record about my correspondence, annexure I. The intervening period which was being noticed by my lords, I had corresponded with. So, my lords, the facts may be wrong. It is on 24 to 2020.
Where is the document?
Yes, annexure I to the counter affidavit.
Page number.
Turning page 136. It's internal page 71 of the counter affidavit. They have brought on record. I say that I will be completing if the time extension and the
Who has?
Lordship, this is they have brought on record.
Lord, I'm having an original copy of affidavit.
If you give like this, which is the document?
Lord, pagination has been done, my lord. I'm just giving.
It is on 24th February 2020. And they have blacklisted me also for 10 years for my this, for their inaction.
This is still worst case. Because we have noticed that as on 16/1/2020, now you are pointing out February 2020.
My lord, in fact, your lordship.
16/1/2020.
In fact, your lordship, would you please to see an annexure H?
16/1/2020 is the date on which 1 week time was granted.
And then
After you are making correspondence for the first time in the month of February.
that I can't do because of that.
In fact, by annexure H to the counter affidavit instance granted, and he was required to complete the work of 30th June.
Plus, that order may be stated that risk and cost because unless that
The
order
writ
is
application has been disposed of.
risk and cost order.
Huh?
Risk and cost wala order.
No, sir.